Good evening, ladies and gentlemen. Falcha, welcome to the 11th Annual Distinguished Lecture in Law at the University of Galway School of Law. We've missed 2 years. It's not the 11th in a row because of COVID, so it's good to be back and to have you all here this evening. Welcome. We're live streaming this lecture and we're recording this evening's lecture, as I know that some people who wanted to be here couldn't make it. So if you're watching later, I hope you're enjoying it. If you're watching live, I hope you will enjoy it. Welcome to those who are joining online just now. It's good to see so many students, staff, practitioners, and alumni here this evening to hear our distinguished lecturer, our esteemed colleague, Mr. Tom O'Malley, Senior Counsel. Tom's lectures have always been a draw here in Galway. I've been told that he once used to lecture at 6 o'clock on a Friday evening, and students would turn up in their droves to listen to him before they headed out for their Friday night revelries. Now, not many lecturers could manage to fill a lecture theatre at 6 p.m. on a Friday evening, but then Tom is no ordinary lecturer. But before I'm tempted to introduce Tom, I better stop, because I'm only the supporting act for the man who is to formally introduce Tom this evening. We're privileged to have fulfilling that role the Honourable Mr. Justice Peter Charlton of the Supreme Court of Ireland. Justice Charlton was called to the bar in 1979 and became Senior Counsel in 1995. He served on the High Court from 2006 to 2014, since which time he's been a Justice of the Supreme Court. Justice Charlton is an adjunct professor of criminal law and criminology here at the University of Galway. We're very honoured that he accepted our invitation to formally introduce Tom this evening. Before I do hand over to Justice Charlton, let me just say that following the formal introduction and then Tom's lecture, there'll be a question and answer session afterwards, and Tom will invite anybody who wants to ask him some questions to do so. So if you do have questions, please wait. There'll be a couple of roving mics going round. It would be a shame not to be heard, particularly those online will need to hear the question. So put your hand up. Tom will indicate that he's willing to take a question from you, and then the mic will come to you and you can ask Tom your question. And after that's finished, we'll repair outside where there'll be some refreshments for everybody here. So I think that's enough by way of introductory remarks from me. So I'll hand over now to Justice Charlton to introduce Tom.
Thank you very much, Martin. Well, ladies and gentlemen, the point of this is to hear Tom O'Malley and not to hear me. So 500 words, and I will be brief. Tom, who finally, after, believe it or not, 48 years working in this university, is to hand in his spurs as an official lecturer in the law school, but hopefully will remain around this place as an inspiring presence for many years to come. So, rivalry in the groves of academia, it exists, you know. And if the contest here is as to who is the most educated person in the room, well, the laurels might go to someone who has a first-class honours degree in French, in Latin, in Greek, and in law from here, from Yale, from the King's Inns, and with complete fluency, not only in English, but in Irish. But that is less important than the contribution our friend has made. In the field of sentencing analysis, he reigns supreme, and that is a subject on which his several books, the latest which is to come this year, have guided the courts on what is the most intractable issue in criminal litigation, one where we will never find a perfect solution, but where he has helped move us judges towards reason and has placed the views of victims to the fore. And the same might be said for his books on sexual offences, where not only the accused facing trial, but also the victim are acknowledged as exercising and benefiting from human rights. But education for its own sake, as a snob value, if you like, is useless. Tom, as you know, has not been a flower born to blush unseen and waste its sweetness on the desert air, as the poet says, but a practical man, a practical version, in fact, of the Renaissance man. As a judge, coming into a court where you don't know if you'll be guided or perhaps not so guided, life can be a lottery. But I think I break no confidences of my colleagues, all of whom today said to give my best wishes to him and to you. when you see on coming into the court that Tom O'Malley SC is arguing a point on appeal, we could never be better served. And that is because of wide culture, that knowledge of literature, of language, that experience which he has deployed to the great benefit of 3 generations of students. And for all I know, Tom could be currently teaching someone whose grandmother or grandfather he taught many years ago. I don't know if it's true or not. But Tom said to me outside that he was going to speak in Greek. So, what about Tom? Could it be this? To loipon adelphi, osa estin alithi, osa sima, osa dikaya, osa arna, osa prosphili, osa efima, etis areti, etis epainos tafta logiseste. So, whatever is true, whatever is noble, whatever is right, whatever is pure, whatever is lovely, whatever is admirable, if anything is excellent or praiseworthy, engage with such things. I don't know if Tom knows that that's from St. Paul. I think he probably does. I'm absolutely sure that he does. And I don't know either whether Tom is a religious person or maybe, like St. Peter and St. Andrew, the apostles, he was chosen, as were they, for their attitude of being a hard worker. And maybe having done so much, he follows the precept of the great Irish poet Sean O'Riordan, Introduction to Rubble Spidoga in 1952, that work means thinking of others, or as does prayer, and that work for others has an eternal significance, because as the poet said, an sin togan an gech, agus as an gech, a ginter an rod, nua marchon, no aglish, no brogue, no fuam, egamian vunla, agus a fadger fein. Ach se rin nua se be padrecha a shin sherle foil coma lena padger fein. Be padger an altere, agus padger na halterachta, agus padger na haglish le foil san aglish. Whatever his philosophy, Tom has lived a life of service to this university, to our legal community, and to the people of Ireland. So, bear bua agus bana a humish.
Well, thank you very much, Judge Charlton, Garbahagat. And indeed, I'd like to say a warm word of thanks to Judge Charlton for coming here this evening. I know that he was sitting on the Supreme Court today and has made a very fast journey here to Galway this evening. So we're very grateful to him, but then he's a very good friend of the law school anyway. As Martin said, he's an adjunct professor here who comes here quite frequently to give lectures and seminars that are always not just of great benefit, but greatly appreciated by our students. So thanks to him. And also, I'd like to thank Martin, the head of school, Martin Hogg, for having invited me to give this lecture and for having put so much work into the preparation and to the organization of it. And I know in that, I definitely know in that, he has been greatly facilitated by Stella Carthy, who is the administrator, one of the administrators of the law school. But I suppose that there's one general thing I would like to say on this occasion. It is that we are so fortunate in the law school to have a wonderful body of administrative staff. And I don't think that the students realize how much what they actually are delivered in terms of lectures, in terms of administration, in terms of exam results and so on, is due to the work of Stella, also Carmel in particular, who has been a tremendous, I think we regard her as the great the great support for all of us within the law school, to Mike Coyner, who has put all of this together this evening, to Tara and to Lorna, and to all of the people who work there. So I think that I just like to take out to welcome so many friends, old friends, here this evening. I know some of you have travelled a long distance. I might, I suppose, be forgiven if I was to single out perhaps the person who has travelled the furthest to be with us this evening, because it gives me great pleasure to do so. That is my successor in the job, Dr. Rory Kelly. Rory at his young age, is by a long shot one of the leading experts on criminal justice and sentencing in these islands. He has a doctorate in that area from Oxford. He has lectured for several years at University College London and has an extraordinary array of the highest quality publications. For example, he is the co-author of the most recent edition of Andrew Ashworth's book, Sentencing and Criminal Justice, which has a worldwide reputation as the leading textbook in that field. So his presence here is a great boost to the law school and indeed to Ireland to have a scholar of that ilk working in an area that will be of increasing importance in the years ahead. So now that he's here, I feel a bit like Simeon. I'm referring, of course, to Simeon in St. Luke's Gospel, who said, once he saw the Messiah, he said, dismiss thy servant, O Lord. But not quite yet. I suppose eventually I'll have to be carried out of the place. But in any event, that brings me to this evening's topic. I chose this topic because I suppose when I was asked to give the lecture, it happens to be an area probably the area with which I am most familiar, but also because of its public importance. Sentencing has undergone very significant change over the past decade in particular, and is set to change even further in the coming years as formal guidelines begin to be issued by the Judicial Council, a matter to which I'll return. The main purpose of guidelines, though it certainly need not be the only one, is to promote consistency in judicial sentencing practice. Consistency is undoubtedly an important value, but what I want to argue in this paper is that that sentencing reform, whether through guidelines or any other strategy, is of little value unless it produces a sentencing system that is moderate, proportionate, and constructive, as well as consistent. So I'll begin by asking if consistency matters at all, or whether there is more to be said for the traditional discretionary approach that we have favoured. That explains the practical wisdom element of the title. Consistency, I will argue, is important, but a moderate and effective sentencing system cannot be produced through formal guidelines alone. The maximum sentences specified by statute and the availability of an effective parole system are also of prime importance. Secondly, we must recognise that today criminal sentencing is only one means, and in some respects an increasingly important means, of punishing certain kinds of crime and misconduct, notably in the white-collar, corporate crime and financial malpractice areas. Regulatory bodies such as the Central Bank and the Data Protection Commission are now empowered to impose very severe financial penalties for various kinds of corporate and white-collar misconduct. Therefore, we can no longer think of state punishment solely in terms of criminal sentencing. We must also take account of the extensive punishment powers conferred on regulatory agencies, and that explains the regulatory element of the title. So while I'm very much focused on the future, I'm going to have to start in the past with this gentleman here called Aristotle. This is the bit that will relate to what I'm calling practical wisdom, and to one of his works, namely the Ethics, and specifically to Book 6 of the Ethics, which dates from the 4th century BC. In modern English translations, that book is usually given a title like The Intellectual Virtues. But what he's saying is actually fairly straightforward. He's saying that there are different ways of thinking and of discovering the truth, and that different people have these qualities in different degrees. He lists a number of them, including science, technical skill, intuition, theoretical wisdom, and also what he calls in the original Greek phronesis, which is usually translated as practical wisdom or prudence. Aristotle saw this as the essential quality of the political leader. But what exactly is it? Well, as always with Aristotle, we are faced with the problem that many of his surviving works, including the Ethics, consist of his lecture notes rather than texts prepared for publication. However, at the risk of oversimplifying and taking what we can from the text, we can say that the person who has this quality of practical wisdom is somebody who isn't necessarily a theorist or an original thinker. In fact, at one point, he seems to say it would be better if they were not a theorist, but who can understand theories and principles and then apply them in a pragmatic, objective, and rational manner in policy making and decision making. This in turn requires close attention to the particular circumstances of each case, as well as to the governing precepts and principles. As he writes, practical wisdom is not concerned with universals only, namely general rules. It must also take cognizance of particulars, because it is concerned with conduct, and conduct has its sphere in particular circumstances. That is why some people who do not possess theoretical knowledge are more effective in action, especially if they're experienced, than others who do possess it. So attention to particular circumstances was very much a key factor in Aristotle's concept of justice. And he writes, I suppose, very well in a very modern way about the fact that it is very difficult, in fact impossible, very often for legislators when they're enacting general rules to be able to foresee all of the different circumstances and situations in which they will be required to apply. And therefore, there's always some need for some kind of principal flexibility to allow for rules to be applied in a flexible way. Aristotle actually calls this equity. Now, that's just simply the word that's used by modern English translators. The original Greek word used by Aristotle, epieikeia, usually means fairness, clemency, or decency. But the idea is essentially the same, that there is always a need for some kind of principal flexibility to be able to apply general rules in particular circumstances. And I have just, which I needn't read out, but he does say in the final sentence there, is that all law is universal, and there are some things about which it is not possible to pronounce rightly in general terms. I often think that 2.5 years later, that is probably one of the best arguments against mandatory and mandatory minimum sentences, that you cannot create a rule that will suit every case. But let us return then to the idea of practical wisdom. It has enjoyed a very long afterlife and has been of growing interest in recent times, especially as it applies to professional practice, and also modern philosophers such as the American Martha Nussbaum have written considerably about it. One of the people who I suppose championed it a great deal in the latter half of the 20th century was the leading British political theorist Isaiah Berlin. And I have just quoted there from a piece that he wrote just about a year before his death, when he says what makes statesmen, like drivers of cars, successful is that they do not think in general terms. In other words, they don't ask themselves in what respect a given situation is like or unlike any other situation in the long course of human history. Their merit is that they grasp the unique combination of characteristics that constitute this particular situation, this and no other. What they are said to be able to do is to understand the character of a movement, of a particular individual, of a unique state of affairs, of a unique atmosphere, of some particular combination of economic, political, and personal factors, and we do not readily suppose that this capacity can literally be taught. Now, Berlin, like Aristotle, was primarily concerned with identifying the ideal qualities of the statesman in the language of the time, or the political leader we say today. But the same, of course, can be applied to anyone charged with making important decisions of a public nature, including judges. So therefore, in a political or legal system where practical wisdom is considered the most desirable intellectual virtue or personal quality, the all-important consideration or challenge is to choose very carefully those appointed to key decision-making roles. The emphasis must be on appointing persons who are most gifted with this quality. Then once they are appointed, the argument runs, they should just get on with the job. And we can be fairly confident that they will get it right or about right most of the time. Nobody ever gets it right, whatever that may mean, all of the time, but it's no mean achievement to get it right some of the time. I'm just describing that idea for the moment. Of course, there are problems with this notion of practical wisdom, and that is how exactly you identify it. If I was to ask members of this audience to point out, well, who do you think is most gifted here with practical wisdom? We'll omit the judges. Who is most gifted with practical wisdom? We'd all be polite enough to point to somebody else. But of course, secretly, many of you would say, well, actually, it's me, you know. Unless you went to a good school, in which case you would say it is I. But we're all inclined to believe, you see, that we are uniquely gifted with it. And we can all think of at least a half a dozen of our acquaintances who are decidedly not so gifted. Don't feel guilty about that, because there are many more who feel the exact same about you. So there is that problem about how you identify practical wisdom. And we must also be aware of the relationship between power and knowledge, that just because a person occupies a role where they may be expected to exercise practical wisdom, that they actually possess it. But having said all of that, I wouldn't knock the idea, nor would I deny that some people, by virtue of experience and disposition, are endowed with it. When it is genuinely present and conscientiously applied, it can doubtless produce good decisions, but not necessarily consistent decisions. And that brings me to the principal question, the first question I want to ask. Does consistency matter in decision making? Is it actually a feature of good decision making? Well, now a few weeks ago, I should say, Baroness Honora O'Neill, a leading philosopher of our time, delivered the John Kelly Lecture at University College Dublin on the topic Philosophical Views on Judgment. And you can see it on YouTube. She took as her starting point a recently published book called Noise, A Flaw in Human Judgment, written by Daniel Kahneman, Olivia Sabuni, and Cass Sunstein, three authors who certainly need no introduction. It's a book that has got tremendous attention and tremendous praise. The title might seem rather strange, Noise, but what they simply mean by that is the way in which different people, even if they are equally expert and highly expert and so on, can reach different conclusions or different decisions when faced with the same set of facts. In other words, the way that 2 or 3 judges might impose different sentences in the same case if they were given the opportunity. That's what they mean by noise. They describe it, and I put up there, they said we defined noise as an undesirable variation in judgments of the same problem. And then they go on to say that when judgment becomes a lottery, it is problematic. Now, they acknowledge that judgments can, of course, suffer from bias, but we all accept that that's unacceptable, undesirable, and therefore they don't dwell on that. What they're concerned about instead is how different people, even when acting with complete integrity and with the same level of expertise and professionalism, can still reach different decisions when confronted with the same set of facts, even though they are applying the same principles and the same standards. And they illustrate this with several examples drawn from sentencing, to which they devote a few chapters, the setting of insurance premiums, medical diagnosis by doctors, decisions on child custody disputes, asylum applications, and so on. For example, they describe an experiment which they call a noise audit, which they conducted in a large insurance company. The purpose was to see how much, if at all, underwriters and loss adjusters vary when setting premiums or estimating the value of a claim. Insurance executives involved in this work accepted that variation occurred when they were, for example, setting a premium, but they estimated the variation would be at most 10%. When the researchers asked 800 CEOs and senior executives from different industries how much variation they would expect in similar expert judgments, the most frequent answer again was 10%. However, the research showed that the median variation in setting a premium was actually 55%. This meant that if one executive quoted a premium of $9,500, an equally experienced executive would quote $16,700 for the same risk. The authors of Noise regard this kind of variation as a flaw in human judgment, thus explaining the book's subtitle. They argue that steps should be taken to reduce, if not eliminate, this kind of variation, and to make various proposals for how this could be done. Baroness O'Neill, in her lecture a few weeks ago, agreed with the authors of Noise that judgment can vary, but she disagreed with them that this is necessarily a flaw. Now, she was concerned more with human judgment than with professional judgment more narrowly, but I think the authors wouldn't have disagreed with her because, for example, we all accept that, for example, literary and artistic judgment can vary. But just turning to professional judgment, which would include legal judgments by judges and lawyers, is variation there something that we should be concerned about? I would say it varies with what's at stake. Suppose, for example, you had 3 highly qualified, more than well-qualified candidates for a job who were suitable, and you arranged for all 3 of them to be interviewed by 2 different interview boards. And again, we'll assume that all the interviewers were equally expert in the relevant area, there's a very good chance that those two interview panels would rank the candidates differently. Is that something we should be worried about? I'm going to say no, not particularly. It's not an ideal situation, but it's probably a price that's worth paying for allowing for professional judgment to be exercised. But suppose a person who is feeling unwell consults two different medical specialists. One tells her that she may be suffering from a serious illness that requires further tests. The other tells her that she is just suffering from stress and all she needs is a good holiday. And I actually know of a case where that happened, and sadly the first of them was right. Should we be worried about that kind of variation in judgment? Yes, of course we should. But what about sentencing then? Should we be concerned about variation in sentencing judgments? We should, basically, because after all, most criminal penalties involve the deprivation or restriction of liberty, or the deprivation of property. I'm talking obviously about things like imprisonment and fines, which are highly valued and strongly protected rights. Additionally, in a constitutional democracy, the criminal justice system should be informed by certain fundamental values, human rights values, such as equality, fairness, non-discrimination, rationality, and proportionality. These rights and values are scarcely protected or honored in a system of sentencing where, in the words of the authors of Noise, it becomes a lottery. The penalty imposed on an offender should not vary to any significant degree, depending on who the sentencing judge happens to be on the day. Now, I would emphasize the words "to any significant degree," because there will inevitably be some variation. One could try to eliminate all variation by having a system of fixed penalties, but I think that cure would be much worse than the disease. So therefore, to answer the question, at last, does consistency matter? I say yes, but it's not all that matters. Don't forget that consistency tells us nothing about how severe or how lenient penalties should be. All that matters is that they should be similar, so that a uniformly harsh system of punishment would be just as consistent as a uniformly lenient or moderate system of punishment. Consistency is observed once unwarranted disparities are eliminated from the system, however harsh or otherwise a system may be. Lyndon Harris puts it well in his recent book, Achieving Consistency in Sentencing, when he says that consistency is agnostic as to the aims. In other words, it's only concerned about ironing out disparities, but it doesn't tell us anything about what level of penalties should be imposed as long as they are broadly similar. Now, I don't want to say before I go any further that consistency is unimportant or without value. It's important in promoting distributive justice, I should say, by ensuring that similar cases are treated in a similar fashion. However, and additionally can promote public confidence in the system. But what we should be trying to achieve is a system that is not only consistent, a sentencing system now that is not only consistent but moderate and proportionate as well. And this then raises the question of whether guidelines can help to promote these values within the sentencing system. I believe they can, but first of all, I have to engage here in a short historical excursus just to explain briefly where we have come from in terms of guided sentencing and where we are likely to be going to. It's rather appropriate, I suppose we always look out for an appropriate anniversary to hang our hats on, but it so happens that 35 years ago, almost to the day, on the 13th of May, 1988, the Supreme Court delivered two important judgments in this country on sentencing. This was actually the first time that the court was ever asked to identify what the appropriate sentence was for any offence. In fact, it has dealt with two. Conroy dealt with manslaughter and Tiernan dealt with rape. Now, I want to dwell on the Tiernan case, which was decided on that date. It was a very egregious case of gang rape, and the defendant, Tiernan, one of the defendants, was sentenced to 21 years imprisonment, and that was upheld by the Court of Appeal. He was enabled to appeal to the Supreme Court, rather unusually, as a result of a certificate granted by the Attorney General, which would have been required at the time. And one of in framing the certificate, the Attorney General said that the point he wished the court to address was, what were the appropriate guidelines for sentencing for rape? Now, there was a procedural difficulty about that, I might add, because the grounds of appeal didn't make any reference to that point about guidelines. But in any event, the Supreme Court made clear that it did not consider it appropriate to lay down any guidelines. Delivering the majority judgment of the court, I should say the court reduced the sentence from 21 years to 17 years, delivering the majority judgment of the court, Chief Justice Fenley noted, first of all, that there were no reliable data on existing sentencing practice, on which guidelines might be based, and he was certainly right about that. In fact, he wouldn't be too far wrong today either. But more significantly, for present purposes, he went on to say, furthermore, having regard to the fundamental necessity for judges in sentencing any form of criminal case to impose a sentence which in their discretion appropriately meets all the particular circumstances of the case, and very few cases are particularly similar, and the particular circumstance of the accused, I doubt that it is appropriate for an appellate court to appear to be laying down any standardization or tariff of penalty. And likewise, Mr. Justice McCarthy, who was, I think there may be one little bit missing, Mr. Justice McCarthy, who was the fifth member of the court, he would have upheld the 21-year sentence, but he too emphasized in his, as well as party dissenting judgment, that it was important to ensure that there was true judicial discretion in every case. What these statements represented was, you could call it an Aristotelian approach. The court was saying that sentencing decisions are best left to the practical wisdom of trial judges, with the implied qualification that a sentence that seriously diverged from the norm could be corrected on appeal. Now, you might say, well, they're only talking about discretion. True, but I would follow HLA Hart, who argued that discretion, properly understood, is not about choice. It's not about being able to choose what you want from a range of options. He actually equated discretion with, in fact, practical wisdom, which calls for rationality and objectivity in decision-making, even where a number of different outcomes are legitimately available. Therefore, that was Tiernan 35 years ago, effectively rejecting guidelines and emphasizing discretion. But actually, Tiernan isn't the only anniversary that we are marking now. 50 years ago, in 1973, a short book was running to about 120 pages, was published in New York, which was called Criminal Sentences, Law Without Order. It attracted a fair bit, the author, Mervyn Frankel, was a federal district court judge. It attracted a fair bit of attention when it was published, but it is now regarded as one of the most influential works in the past century in the field of criminal law. And this assessment is probably justified because it led to a profound, indeed revolutionary change in American sentencing, a change that would reverberate later in many parts of the world, most recently here in Ireland. Frankel excoriated the American sentencing system for its inconsistency and arbitrariness. He certainly had a point, though some later claimed that he exaggerated the problem. However, when reading it, and when you're considering the kind of circumstances that led to the adoption of American guidelines, it's important to remember that appeals against sentence were unknown in America at that time. Merit-based appeals against sentence were introduced in all the jurisdictions of these islands in the early 20th century, but this had not happened in America. Secondly, American sentencing at this time was truly indeterminate. In some jurisdictions, a judge would impose a present sentence of, say, 1 to 10 years, and it would be entirely up to the parole board to decide when the person should be released. The theory was that the parole authority would decide when the prisoner was sufficiently rehabilitated to be released, but this soon became theory and certainly not practice, because it became impossible to evaluate all prisoners individually. And so the practice was that prisoners were released on serving 1/3 of their sentence. Frankel in that book concluded by recommending the creation of a commission on sentencing, the functions of which would include the enactment of rules governing sentencing. Frankel's book might have faded into obscurity had it not caught the attention of Senator Edward Kennedy, who became its main champion at political level. During the next decade, Kennedy campaigned strongly for federal sentencing reform, and his efforts bore fruit under the Reagan administration, as it happens, with the enactment of the Sentencing Reform Act of 1984. This provided for the creation of federal sentencing guidelines, which entered into force in 1987 and which, with some amendments, still apply. These are grid-based guidelines that govern all federal offences. And I think I have an example there. That is what it looks like, that along the vertical axis there, you'll see offence levels of 1 to 43. Along the horizontal axis, you have criminal history score. So that the score you get there will depend on the number of convictions that you have, and where the sentence that you deserve for the offence will be at the intersection of the two. So they have somebody, for example, had a criminal history score of 20, sorry, I beg your pardon, an offence score of 20 and a criminal history score of, let's say, 3, well, then they would get 41 to 51 months imprisonment. That is the way that is typically the way American guidelines work in both the states and in the federal system. They're based around a grid with, of course, a huge emphasis put on previous convictions. Now, as it happens, they have found no imitators elsewhere precisely for that reason. They have been considered in Canada and Scotland, but rejected them both because of the so-called recidivist premium. That is the greatly increased sentence imposed on offenders with previous convictions. But there have been some amendments to the federal guidelines since 1987, and now they're largely advisory, but they certainly had, this was a very important moment because it showed, even though we haven't imitated them elsewhere, it showed that it was possible to have guided sentencing of some kind. And other countries then went their own directions in how to do it. So there was, if you like, policy transfer more than anything else. When England and Wales introduced formal guidelines about 2003, 2004, it took a different approach. What was then the Sentencing Guidelines Council, now the Sentencing Council, developed guidelines incrementally on an offence-by-offence basis. By now it has developed separate guidelines for virtually all commonly prosecuted offences, as well as so-called generic guidelines dealing with general matters such as how to assess offence seriousness and give discount for guilty pleas. However, in contrast to American guidelines, the English guidelines are more narrative in nature. They specify sentence ranges, okay, but they also devote a good deal of descriptive material to setting out the factors that should influence, that should increase or decrease culpability, personal mitigation, and so forth. So what then has been happening in Ireland? Have we been influenced by this movement towards guidelines? Well, we saw that back in 1988 they were rejected, and that remained the orthodoxy for the next 25 years. The change came quite suddenly and in an unheralded way in March of 2014, where the Court of Criminal Appeal, then in the final months of its existence, suddenly issued 2 guideline judgments. This was an entirely, as I say, unheralded development, and the court got around the Tiernan problem, if I call it that, what the Supreme Court had said, by interpreting what the Chief Justice has said literally. And you recall what the Chief Justice said, that he doubted if it would be appropriate to lay down any standardization or tariff of penalties for offences. The Court of Criminal Appeal said that it agreed with this, but that it did not preclude it from setting out broad sentence ranges. And it then proceeded to do just that for 2 offences that came before it in 2 different cases on the same day. Ryan dealing with possessing a firearm in suspicious circumstances, and Fitzgibbon, which was the offence of causing serious harm. And so the guideline they laid down in Fitzgibbon was as follows. Causing serious harm carries a maximum sentence of life imprisonment. And so the court identified 3 ranges: lowest 2 to 4 years, middle 4 to 7.5, highest 7.5 to 12.5, with the possibility of going higher still if necessary. That's the only guideline I'm going to actually describe, because otherwise we'd be here all night. But that is the kind of structure, broadly speaking, that Irish guidelines have followed so far. The present Court of Appeal, which came into existence in the autumn of 2014, issued its first guideline in a case called Casey, which dealt with residential burglary, and has issued several other formal and informal guidelines since then. Typically, the court divides the sentence scale into 3 ranges, low, middle, and high. Therefore, if you have an offence that carries a maximum sentence of 9 years imprisonment, the lowest range would be 0 to 3 years, the middle range would be 3 to 6 years, and the highest range would be 6 to 9 years. Where an offence is punishable with a maximum of life imprisonment, the court usually assumes that the effective maximum is 15 years imprisonment, and therefore sets the ranges accordingly. As I say, the Court of Appeal has developed a very significant number of such guidelines. I was in quite a number of those cases, and of course, there was always this niggling doubt in the back of our minds. It's all very well for the Court of Appeal to be doing this, and what's the Supreme Court going to say? A bit like what will your father say when he gets home? Because after all, Tiernan still applied. Well, happily, I'm happy to say the Supreme Court is very happy to introduce guidelines. In fact, in the Mahan case, which is the first one, they invited us to make submissions as to what the guidelines for assault manslaughter should be. And so there have been at least 3 significant cases. All the judgments had to be delivered by Judge Charlton, as it happens. In the Mahan case on assault manslaughter, and the FE case on rape, and a case called Malloy on harassment. So I'm not going to describe the guidelines any further, as I say, but what I want to do is just at this point take stock and say, where do we now stand? Where have we come from? Well, what we have seen over the past 35 years, I should say, is a profound change in judicial attitudes towards guided sentencing. We have seen a transition from strong resistance to enthusiastic acceptance. Strong resistance having been in Tiernan, the enthusiastic acceptance having, I suppose, developed from Fitzgibbon in 2014 onwards. Various reasons might be suggested for this change. One is that, of course, the courts were coming in for increasing public criticism for what was perceived to be inconsistent sentencing, especially as the media became less deferential to the courts than they were in the past. Secondly, a new generation of judges came along who were more receptive to innovation, including the opportunities afforded by information technology, and they adopted a more open-minded approach to guided sentencing. Perhaps the most compelling explanation is at a deeper level, and it is the general commitment to procedural justice and reasoned and transparent sentencing and other decision-making on which legal systems in democratic countries now insist, that it is not enough to give unreasoned decisions. Back in the 18th century, Lord Mansfield, I suppose one of the great architects of the common law, was contacted by a relative of his who had been appointed a colonial governor and whose duties would include resolving disputes. He was seeking advice from Mansfield as to how he should go about the business of judging. Lord Mansfield replied, "When it comes to deciding disputes, do whatever you think is just, but on no account should you ever give reasons. Your judgment will probably be right, but your reasons will certainly be wrong." I think many of us who correct exam papers find that. I mean, the nightmare scenario would be somebody who can you tell me exactly why I got 67 instead of 68? Or indeed anyone who sat on an interview board likewise. So again, as I say, we have made that transition for various reasons. But we're now about to enter a new era as a result of the Judicial Counsel Act of 2019, which creates a Sentencing Guidelines and Information Committee, which is charged with a number of functions, the most important for present purposes being to prepare draft sentencing guidelines for adoption by the board of the Judicial Council. Those of you who may not be familiar with it, the Judicial Council will consist of all serving judges. The board consists of 11 judges, including the presidents of all the courts. The Act gives the committee considerable latitude in relation to the kind of guidelines it draws up. It seems to envisage guidelines more or less along the lines of the English model, but it certainly doesn't require that our guidelines should be similar or exactly similar to theirs. However, it provides for both offence-specific guidelines and general guidelines. And the factors to which the committee must have regard when drawing up guidelines include the sentences currently imposed by the courts, the need to promote consistency, the impact of sentences on victims of crime, and the need to promote public confidence in the sentencing system. One all-important consideration, of course, when it comes to drawing up sentencing guidelines, is the extent to which they are to be binding on the courts. Can the courts just ignore them? Well, here the Act, I think, cobbled together provisions from two English statutes, as it happens, and it provides that a court, when imposing a sentence, shall have regard to the relevant guidelines unless it is satisfied that it would be contrary to the interests of justice to do so. But therefore, that work is now, as I know that our colleague Jeremy Griffin is a member of the committee, and we can therefore, I suppose, expect to see guidelines of one kind or another being produced by the Judicial Council over the next few years. So what I want to ask then is, what can guidelines actually achieve? And what should we be thinking, what kind of factors should we be bearing in mind in the present climate? If I was to adopt the title of a well-known literary work, going back to even before my student days, a very famous work on literary criticism by an American called Abrams, which was called The Mirror and the Lamp, I think that is a good metaphor for sentencing guidelines. Should sentencing guidelines aim to be a mirror in the sense of reflecting existing practice, or should they try to be a lamp in the sense of illuminating a different way forward in the past? There is a lot to be said for the mirror approach, because if guidelines reflect existing practice, well, then judges and lawyers are far more likely to accept them. They don't see any great abrupt change. And that is certainly true, and empirical research elsewhere has pretty much shown that. But there are other considerations to be borne in mind, especially at the present time. And one of those is the problem of overcrowded prisons. On the 4th of May, 2023, because nowadays on the Prison Service website, you can actually get the details of the daily population for each day in prison. On the 4th of May, that's exactly a week ago today, the number of prisoners in custody was 4,583, which meant that we had a prison capacity of 104%. The women's prison in Limerick was operating at a capacity of 171%. And the men's prison in Limerick, 130%. Now, as it happens, just before it came out this evening or this afternoon, I checked out the data for, I think the last day they had was Tuesday of this week, and they're pretty much the same. This is utterly unacceptable. On the same date last year, there were 4,000 prisoners in custody, so we have seen an increase of 600 in the course of a year. It is very difficult to foresee this situation improving anytime in the near future. One is only to consider, for example, the number of cases pending before the Central Criminal Court alone at the moment, and don't forget that court deals only with murder and rape cases, very serious cases. Consider also the large number, for example, of drug seizures and associated arrests that we're seeing. Consider offences such as money laundering and drug trafficking, about which we hardly ever heard until recently, but they are increasing in prevalence, and when there are convictions, they will definitely attract heavy sentences. All of these factors, not to mention, and quite rightly, of course, giving greater attention to things like domestic violence, coercive control, and so forth. All of these things, of course, put upward pressure on the prison system. What's the solution? Well, one solution, I think it was mooted by the minister a couple of weeks ago, is simply to increase prison capacity, to build more prisons. Well, that brings its own share of problems as well, not least the logistical difficulty that's involved in building more prisons. When you consider the legal hoops you have to go through nowadays to build a garden shed, you can imagine what it must be like to build a prison. And of course, we have the Thornton Hall fiasco of a decade or so ago, to remind us of that. But it's not the only solution. Warehousing large numbers of prisoners in overcrowded conditions for lengthy periods does little to promote public safety in the long run. Now, the reason I think this is important to talk about in the context of guidelines is that there is inevitably one problem with guidelines that we have to accept, and that is that they do tend to emphasize imprisonment. There is nothing inevitable about this. It's more a matter of convenience. Simply put, when you're drawing up guidelines, as you can see it from the from the federal guideline, these are all terms of imprisonment that you're looking at here. Now, above those in zone A, B, and C, which of course are minor or much less serious offences, there is a possibility for a court to impose probation instead. But as you can see, they're all about imprisonment. And the same is true of other guideline systems. So we have to be careful about that. As I say, it's easier to think in terms of prison sentences and to specify terms of custody than to try developing three-dimensional guidelines that would recommend non-custodial penalties equivalent in severity to short and medium-term prison sentences. There is a fair bit of research done on that. But can you actually identify non-custodial penalties that are equal to, let's say, 12 months imprisonment or whatever? And yes, you can, but it is quite an intricate task. For example, I mentioned a moment ago the famous book by Marvin Frankel, if I can bring it back there, which I'll say is highly praised, well, by some at least, and it was highly influential. And there a few weeks ago, just I suppose as a mark of its importance, there was a major conference in New York to celebrate the 50th anniversary of its publication, which was addressed by leading judges and scholars of the United States. But it wasn't an occasion for unalloyed celebration. Nobody could take away from its influence. But what nobody could deny either was the impact that the guidelines have had on levels of imprisonment. For example, in 1987, when the federal guidelines entered into force, there were 44,000 federal prisoners. Today, there are 153,000. Now, again, you cannot attribute all that to guidelines, which you can to a considerable degree. I should say, of course, that most American prisoners are held in state prisons and in local jails, so the total population is about 2 million, but we're just talking here about prisoners in the federal system. Therefore, any body or commission or committee charged with developing sentencing guidelines must remain constantly and acutely aware of the impact its recommendations will have on the prison population and on the need to avoid imprisonment where possible. I'm not just thinking here about prison overcrowding itself, but also the impact that prison has on individuals. It can do this, for example, by producing a general guideline on sentencing options, including guidance on where the custody threshold should be set or deemed to have been passed. And likewise, in its offence-specific guidelines, it can recommend non-custodial sentences, at least with the possibility of non-custodial sentences for the lower categories of some offences, and then try to make recommended prison sentences where necessary in the higher orders, higher ranges as moderate as possible. But my main message in this regard is that a sentencing guideline body in itself or on its own cannot achieve parsimony in punishment and moderate prison sentences. After all, when setting guidelines, it must have regard to the maximum sentences that are set by statute. Where those maximum sentences are high, as they almost invariably are nowadays, they will probably result in higher guideline sentences. The higher the maximum, the higher the recommended sentence ranges will be, actually enough. And I can illustrate this by, I think quite nicely, or well, I'm not doing it nicely, but it's a case that illustrates it nicely to prove this point. There's a case called Lennon, which was decided by the Court of Appeal, and I forgot to put in the date, but I think it was 2021, which offered guidance on the offence of sentencing witness intimidation. Now, that is an offence that carries a maximum sentence of 15 years imprisonment. And therefore, the Court of Appeal adopted the tripartite approach. It said, in the lower range, it carries a sentence of 0 to 5 years. In the middle range, it carries a sentence of 5 to 10 years. In the higher range, 10 to 15 years, perfectly in order. And there were the ranges that the court recommended and applied. But there was something interesting about that offence. And that was, when it was first introduced in 1999, it carried a maximum sentence of 10 years imprisonment. That 10 years was increased to 15 years imprisonment in 2009 for no particularly good reason. I went back and looked at the Dáil debates, and the Minister for Justice simply dealt with this in one short sentence, where he said that he was increasing the maximum sentence because the guards wanted it. Effectively, that was said that he was asked to do so by the guards. Now, the reason that's significant is that if, of course, the 10-year sentence had continued to apply, the 3 sentence ranges recommended in Lennon would have been different. Would have been about 1 to 3 years, 3 to 6 years, 6 to 9 years, or whatever. We'll say that were considerably higher. So therefore, if you're going to bring about, some kind of moderation and indeed rationality into the system, you have to look at maximum sentences as well as guidelines. And there is, of course, the other problem about maximum sentences, which is that they tend to be incongruous. There isn't sometimes any coordination between them. They have often developed as a result of historical accident. And if you want the classic piece of writing on that, I'm happy to recommend our new colleague, Dr. Rory Kelly, who has written what is regarded as a classic article on that topic in the 2018 Criminal Law Review. But what he has to say there about English maximum sentences would equally apply here. So therefore, what I would recommend is that there does need to be a general review of maximum sentences as part of bringing about a more coordinated system. But I wouldn't be remotely optimistic that will happen. Legislators will tend to be very, very reluctant to reduce maximum sentences. But I think at the very least, they should take this into account when creating new offences. But there is something that legislators and government could do, and that is to revise our parole system. Now, this might seem like a very strange recommendation for me to make, since our parole system was only introduced in 2019, less than 4 years ago, in the Parole Act of that year. This act has some very good elements, especially in relation to procedural rights, but is deeply flawed on the all-important question of eligibility for parole. It provides that a person serving a life sentence does not become eligible for parole until they have served 12 years in custody, although it's unclear how the 12 years figure was arrived at. However, when it comes to prisoners serving determinate sentences, so for those of you who may not be in the legal world, that means a sentence of a fixed term, such as 2 years, 6 months, or 12 years, or whatever, the Act simply, if you like, kicks to touch, because all it does is it provides that the Minister for Justice may specify that these people will be eligible for parole, but he can only do so in respect of prisoners who will be serving 8 years imprisonment or more, and in fact he can go higher than 8 years in specifying the minimum term in respect of which parole release will be available. Then there's the all-important question, which any decent parole act anywhere in the world would of course lay out very clearly, because it is quintessentially a legislative task. What portion of the sentence should a person have to serve before they become eligible for parole? I know this is Ireland. It doesn't do that. It simply says the Minister for Justice may specify what portion of a sentence that a prisoner has to serve before they will become eligible for parole. So therefore, the Act is deficient in that regard. And in fact, if you look at the website of the Parole Board, what it says is that it's a body that's charged with dealing with granting release to life prisoners. The Minister, to the best of my knowledge, hasn't yet brought into force those sections of the Act that would allow for parole for people serving determinate sentences, and there's no sign of that happening. I think it's very important that it should happen, because that is a very effective way of keeping the prison population under control. Parole can be a very, very beneficial way and a very effective way, not just in terms of providing leniency for prisoners, it can very often be very effective in public protection as well. Ironically, it is very often the most dangerous prisoners, if you like, are the people who are most likely to offend, who need parole most. Because after all, if they serve their full sentences to the end, they will be released without any supervision at all. If they are released at some point throughout their sentences, they will be subject to probationary supervision, with the possibility of recall, obviously, and therefore it can be a far more productive way of dealing with and trying to promote desistance from crime. But in addition to that, I would think that developing a proper parole system where every prisoner would be entitled to parole if they're serving, let's say, a sentence of more than 2 or 3 years, that they would automatically be considered for parole at the halfway mark at most. So that is certainly one of the other factors, I think, that has to go into this jigsaw about how to bring about a moderate sentencing system. And then finally, in this regard, and I'm going to the end of the sentencing of history, can be glad to hear in a moment, we need to have an honest, though a very difficult discussion about another topic, and that is the relationship between sentencing and victims' interests. In the time available, I can only mention this topic. However, there is a common assumption that for some offences at least, the heavier the sentence, the greater the relief or the greater the justice done to the victim. One comes across cases where a victim will feel undervalued if the offender got, say, 5 years imprisonment, but validated if the person got 7 years. Have to ask, well, what was wrong about 5, but right about 7? So that's something that we need to have a discussion on. And I think the Court of Appeal in the case called Crowley, decided in 2021 also put it very well, when it said that of course victims have an entitlement to see justice done, but they have that entitlement as members of the public and not as necessarily as individuals, that we cannot have a punishment system depending on whatever the views of the individual victim might be. So to sum up, therefore, in terms of what I have to say about the future of sentencing guidelines, I would say, yes, they can generate consistency, and that's an important value in itself. However, there are other equally important values, one of which I'm emphasizing here, which is moderation in punishment. A guideline-setting body, such as the Sentencing Guidelines and Information Committee, can go some distance towards achieving this, but it cannot do so alone. Its work must be supplemented by a legislative review of maximum sentences and the introduction of a more effective and inclusive parole system. Also, as I've just said, we need to have a conversation about the relationship between sentence severity and victim satisfaction. I'm almost at the end, you'll be glad to hear, but there is another part of the title of our little event this evening, which is Punishment and Regulation in Ireland. I have included regulation in the title because we have now reached a point where the punishment of wrongdoing can no longer be equated with sentencing by the criminal courts. What I'm about to say here would have little relevance to core crimes, such as offences against the person and the traditional offences against property, but is highly relevant to white-collar and corporate offending and misconduct. Sentencing is sometimes described as state punishment, to distinguish it from punishment inflicted in private settings, such as family parental chastisement of children, or sanctions imposed on members of private associations. However, state punishment nowadays extends beyond criminal sentencing. It can include, for example, punitive damages awarded in tort cases, which we're getting rather fond of here, I have to say, non-conviction-based confiscation of assets, penalties imposed as part of deferred prosecution agreements where they exist, and importantly, financial penalties imposed by regulators, such as, for example, the central bank. Viewed in this light, criminal sentencing is now merely part of a broader sanctioning network. In fact, as far as white-collar crime and corporate crime is concerned, it is becoming an increasingly insignificant part of that network. It has been suggested by, for example, Professor Karen Steiker of Harvard Law School, that this turn to civil sanctioning is attributable to the law and economics movement, with its emphasis on law as a means of promoting efficiency, including transactional efficiency. Granted, it is more economically efficient to have a heavy sanction imposed by a salaried official or group of officials in, say, the central bank, than to have a criminal trial running many weeks or months, which could, of course, result in acquittal. However, I don't think that the impact of the law and economics movement provides the full explanation. After all, the coexistence of criminal and civil sanctions in the United States was being written about by people like Sanford Kadish back in the early 1960s. But I think the law and economics movement, and anyone who has ever read the works of Richard Posner, if you can hold your nose, will probably accept that the law and economics movement has, I think, accelerated it. I just want to, but just these sanctioning systems have remained largely under-investigated in this country, at least. I'm only going to mention 3 of them, and I will be very brief about that. One is punitive damages, which we tend to forget about. There are many different theories of tort law, but I suppose in the modern times, among academic scholars at least, the theory of tort that is most ascendant would be the corrective justice theory, which would be espoused by people like Ernest Weinrib in Canada and Jules Coleman in America. And what that is saying, as the name suggests, is that the purpose of a tort action, the purpose of a tort remedy is compensatory. It is to put the plaintiff in the position that he or she would have been in if the act had not occurred, at least as far as practically possible. Yet, anomalous though it may seem, since the mid-18th century, punitive damages have been accepted and indeed awarded. And if there's one thing that has remained consistent since the very earliest English cases of 1763, right down to the present day, it is that courts have said that the purpose of punitive damages is to punish, to deter, and to condemn, which is precisely, of course, what also the three main purposes of criminal punishment. So the punishment, and we have seen, I suppose, and in Canadian law, breaches of contract can also be, so punitive damages can also be awarded for breaches of contract, as they can in other jurisdictions as well. So therefore, all I want to say here is that in a situation like this, we tend to forget about the fact that in some circumstances, punitive damages can almost be a tort action which is seeking punitive damages can almost be equated with a private prosecution. Because some of the recent cases we have had here in Ireland where punitive damages have been awarded have been cases where in fact the conduct did come within the definition of a crime, but wasn't prosecuted, or it was a breach of a constitutional right. And sometimes, of course, punitive damages can be significant. Now, again, not as in America. If you're following Donald Trump's recent travails, you will notice that of the $5 million he was ordered to pay yesterday, I think 500,000 was punitive damages. Well, that was only loose change compared to some of the punitive damages awards that are made in the United States. But in this country, for example, in the Frank Short case, in 2007, which was a very bad case of police malpractice in Donegal, where Mr. Short ended up serving, I think, 27 months imprisonment for crimes that he didn't commit. He was, of course, awarded €4 or $5 million euro in compensatory damages, but he was also awarded $1 million in punitive damages. One of the questions that arises is who exactly is being punished? Certainly it wasn't the guards who committed the wrong in question, because when you look at the defendants in the Supreme Court case, it was Ireland, the Attorney General, the Garda Commissioner, or if you want to put it otherwise, the taxpayer. Now, I don't begrudge Mr. Short a penny that he got, he deserved it all, but you have to ask the question, to what extent are punitive damages consistent with the purposes of tort law, and are there many cases where people could simply get increased compensatory damages rather than punitive damages? We don't as yet have deferred prosecution agreements in this country, though we may have them in the future. They now exist in many countries where a company which admits wrongdoing can be, rather than be prosecuted, can enter into an agreement that it will adopt certain remedial measures, though in fact that usually requires paying very significant compensation. Again, what's significant about that is that the penalties that are very often imposed would be in excess of anything that would be remotely considered by a criminal court, though admittedly, in England, you're talking about extremely big companies accused of and admitting very serious misconduct. If you take, for example, the most recent, what I think is the most recent DPA concluded in England, may not be the most recent, but it was in 2021, which involved a financial sanction of £1 billion. Actually, it was €1 billion because it was part of an international investigation. But again, that is certainly true. But finally, then I want to come to regulatory penalties, because civil and administrative penalties imposed by regulatory bodies form part of this broader sanctioning network that I have mentioned earlier. Now, in Ireland, for example, the Central Bank, the Data Protection Commission, nowadays the Competition and Consumer Affairs Commission, and many others can impose very heavy sanctions indeed against typically companies, but sometimes against individuals as well. For example, in September of 2022, or by autumn of 2022, I should say, the central bank had concluded 152 enforcement actions with total fines, including amounting to 400 million euro. Some of the individual penalties have been very high. For example, late last year, the central bank fined the Bank of Ireland 100 million euro alone in respect of the tracker mortgages scandal. And there are many other such examples as well. For example, the Data Protection Commission is reported to have imposed more than 1.6 billion in fines between January 2022 and January 2023. So all I'm saying is that, and I can no more with, since I have run out of time, quite by a long shot. The only message that I want to get through is that we need to be aware of these alternative sanctioning systems, and that the task in the years ahead for those of us who work in this field of sentencing and criminal justice is to shift our gaze occasionally away from the criminal courts and towards the civil courts, and also towards regulatory bodies. Otherwise, we will have a very incomplete picture of how crime and financial malpractice are punished within the jurisdiction. So I fear that I have gone on for almost as long as the coronation. Obviously, if Prince Harry was here, I'd have finished earlier so that he'd catch his flight back to her. But thank you very much for listening. Thank you very much indeed. I haven't got one of those since I performed at the National Concert Hall.
I think the floor is open to questions, so it leaves Director Tom away.
Yeah.
Two roving mics, so one on each side here.
Thanks a million, Tom. That was fantastic, as always. I was glad to hear you mention tort law, because like in that area too, they're introducing guidelines. And it's got me thinking, you know, tort being my area, if there's ever such a thing as a correct sentence or a correct amount of money somebody should get, and that if there is, you can see the value of consistency in guidelines. But I suppose the question is, firstly, do you think there's ever such a thing as a correct one? And then the add-on, if you like, is that if there isn't such a thing as a correct sentence, is there still a value in consistency in that everybody at least is negatively affected in the same way? Or do you think we're better off abandoning consistency than in going in favor of noise? So at least there's a chance we get it right.
Yeah, thanks, Ursula. No, I mean, that what you said there, let me just kind of focus in on the tort one to begin with. As you say, is something we don't think very much. And of course, the issues, as you know, that involve, let's say, the calculation of damages and general damages in particular in tort cases are very similar to sentencing, because there has been a great deal of variation there over the years. And of course, it's interesting that the Judicial Counsel Act, in addition to creating a sentencing guidelines and information committee, creates another body for setting out guidelines on that. And so it is very difficult. And if we just leave aside punitive damages entirely and think about compensatory damages, you see, it's all very well for people to say, well, the purpose of compensatory damages is to put the plaintiff in the position that had been in if the injury had never occurred, which is what the corrective theory of justice is about. Of course, we all know it's impossible to do that in most cases. If you have somebody who suffers life-changing injuries as a result of a car crash, from a car accident, no amount of money can give you back the kind of life that you had prior to that. So there'll always be an element of uncertainty and discretion there. But having said that, I think the arguments for consistency in that area are pretty much the same as they are in sentencing. That purely as a matter of fairness and distributive justice, It'd be very wrong if you and I suffer two very similar injuries and you got $500,000 and I got $250,000 in damages. So yes, I mean, there is a value in consistency, provided it isn't, if you like, a straitjacket on taking into account individual circumstances.
Thanks for a very interesting lecture, Tom. I was going to save my question for an email to you later rather than delay us, but seeing that we've got a bit of time, I was just interested in how you thought technology would help this, because I think one of the big challenges I understand from, say, American jurisprudence is when judges now use predictive guidelines, and of course there's a question of bias in those on the
Yes.
past and so forth. But could you foresee a future where, you know, you'd put everybody's characteristics into a program and the judge would get at least some guidance as to what they should give as a result? Is that going to be what we're talking about in 10 years' time?
Well, you're talking about algorithms.
Yeah,
type thing.
algorithms, really.
Yeah, right. Yeah, well, of course, that they're very, very controversial in the sense that, I mean, there's no doubt that they can work. It depends on what, of course, as always, you're trying to find out. And I remember once being just by accident, in fact, I'd be at a conference in Cambridge, and there was an inaugural lecture being given there by a new professor of experimental criminology, Larry Sherman, and let's go back about 10 or 12 years more, and he was predicting the day would come when you could just feed in all the information into a computer and out would hop the right sentence. Well, of course, there are two things about that. First of all, what is the right sentence? You see, it's all very well if you were adopting a utilitarian approach where you say the purpose of sentencing is to give whatever sentence will best prevent the person from committing an offense. I mean, if that's your aim, well, then in theory, at least, it might be possible as a result of having a whole lot of knowledge to be able to predict what sentence would most likely produce that aim of desistance or further crime. But of course, if your aim is simply to give what you might call a just sentence, in other words, if it's a policy of just deserts, where your sole function is to punish the person proportionately, it's very hard to decide that in an algorithmic way, but it may be. But the difficulty, just to answer your question directly, is this, that, as you probably know, in America, where this is done quite a lot, there's a lot of unhappiness about these systems being, if you like, internally biased, that the kinds of characteristics that they will very often pick out as being likely to predict further crime being committed will be based on race. And very often they will be based on socioeconomic background and so on. So that they very often, if you like, perpetuate existing disparities by saying, well, this person, because they belong to this racial minority and they have only gone to first level school or whatever, they will definitely commit further crime. Therefore, we need to send them to prison for longer. So, you know, that is one of the difficulties, that they can be internally biased. But I certainly think you're right, with AI going the way it is, and maybe it will improve. And some people say that these systems have improved. That will definitely happen in the future, I think. Yeah. Rory.
Thank you for the lecture, Tom. I wondered who you thought was best placed to promote consistency for regulatory sanctions. Would it be the committee, an appellate court, or the regulator itself?
Good question, Rory. Well, I don't think that, first of all, in theory, you could have any of them. I mean, certainly, the sentencing guidelines committees probably won't bother with regulatory sanctions because they're dealing purely with criminal offences, with sentences by the criminal courts. But it is quite interesting. And in my view, it's an important question. If I had the time, I would like to be more critical about it. Because what I wanted to say was this, that I cannot say, if you like, or let me put it this way, what I was going to say if I had more time. A few weeks ago, a judge, a high court judge, and this is just a routine case that I came across on the court service website, a high court judge had to give damages to a woman who slipped and fell in a hospital, and she sued, and I think the liability was admitted. But the judge awarded her damages, and I had it written down somewhere, but I don't have it with me. But I remember how it ended. It was €41,117.38. Now, I'm sure she was happy about that in the present climate with the cost of living, because, as Tesco used to say, every little helps. But anyway, what got me about it, here you had a very, very specific award of damages being given. The central bank will simply fine somebody €100 million. Now, I'm always very skeptical about any penalty that ends in several zeros, especially 6 of them, or indeed 8 of them in that particular case. So I often wonder to what extent, and I have read the judgments, if you want to call them that the central bank publishes when it imposes these fines, but I have to say they are singularly unenlightening. I mean, they're okay, they are doing their job and all the rest of it, but it's never clear to me at least, well, how exactly did they come up with these sums? And if for all I know, they may be too lenient as well as too heavy. But I just wonder, would they actually pass muster if they had to be judged, let's say, by an appeal court in the same way that a trial judge's sentence would have to be evaluated? And I quite frankly don't think they would. So I think that whether it comes from the courts or some other system, that there has to be more of an onus put on these regulatory bodies to be more specific in terms of how they actually arrive at the penalties that they impose and the criteria that they use for imposing them. So that's as much as I could say in that worry. Yeah.
Thank you. I just wanted to ask on looking at the future of sentencing, is there any thought being given to restorative justice where the perpetrator has to actively work to give something back to the plaintiff? Well, there's a huge literature now on restorative justice, a massive literature on it internationally. And there's some in this country, one of our colleagues at Maynooth Law School, Ian Barder, has written a fair bit on restorative justice, but it's all very well to be writing about it. The big problem is putting it into practice. And I have been reading a fair bit about it recently in a forthcoming book that Charlotte had mentioned. I have devoted a few pages of the introduction to restorative justice. And one of the big difficulties is, and this is the first thing you find written about anywhere, is there's no agreement as to what it means. You know, it means a whole lot of different things to different people. For example, sometimes restorative justice acts as an alternative to criminal justice. In other words, instead of prosecuting somebody, you have the victim and the offender coming together with community representatives and so on to try to figure out some kind of solution to the problem. And sometimes they can operate within the criminal justice system. For example, in New Zealand, when sentencing some offences, the judge can ask or invite the victim and the offender to consult in a structured way and then come back and recommend a punishment. And if the judge is happy with the punishment, they can impose it. So it can operate in all kinds of different ways. But yes, it can. I think whether it operates within or as an alternative to the criminal justice system, I think we should be devoting more attention to it, because what it does is it promotes mutual understanding. The offender gets to understand how the offense affected the victim, and that would hopefully dissuade the offender to some degree from repeating that kind of conduct. It can also be very important for victims to understand offenders and to know the kind of circumstances, difficulties, and so on that probably led to the offending in the first place. So I think that kind of mutual understanding is good. And therefore, I think we should be doing more to promote restorative justice. But I think, to answer your question, I don't think there's anything like as much being done about in this country as there could be.
Thank you. Just as someone, I suppose, that works in one of these regulatory bodies, we're now seeing, I suppose, a move towards more administrative enforcement. I suppose in order to avoid, I suppose, criminal sanction and criminal enforcement. But do you think in it moving towards, I suppose, more administrative enforcement would give the same level of deterrence to, I suppose, the white collar criminals?
Can I just
Can I just confirm that I understand your question? What you're saying is, are there advantages to the administrative system of punishments as opposed to criminal punishment for white collar crime and so on? Well, there are some. Yeah, I mean, there are some. For example, when it comes to corporations, I mean companies, first of all, it can be quite difficult to prosecute a company effectively. Now, for anyone criminal lawyers here will know it. I won't get into the technicalities of it, but the test that you use to decide if a company, and I mean the company itself, is guilty of a criminal offence can be quite a difficult one to prove. Secondly, of course, it can be when a company is convicted of a serious crime, it can have significant collateral consequences because it may be prohibited from seeking certain kind of contracts, trading abroad and so forth. And of course, everyone mentions the Arthur Anderson case in America back about 10 years ago, when I forget how many, was it tens of thousands or hundreds of people who lost their jobs virtually overnight. A huge consulting company that just collapsed simply because it was prosecuted, not because it was convicted, simply because it was prosecuted. And ironically, after the whole thing had collapsed, all these people lost their jobs, the United States Supreme Court actually quashed the conviction. But by then it was far too late for for it to be rejuvenated. So yeah, there are reasons like that why it can be, why administrative sanctions can be more effective for companies in particular. But what I'm saying, I suppose, is that there should also be some kind of rationality to the level of sanctions that are imposed and the reasons why they're imposed and the manner in which they are calculated.
Tom, great to see you defying the aging process. At least 41 years since we first crossed paths.
Indeed.
And enlightening us. Can I just ask you, in terms of principles and guidance, and here we are post-COVID, the courts are been, criminal courts certainly, overwhelmed in effect with a backlog of cases, and the government response seems to be throw a lot more judges at the problem. Whether that will work, I'm somewhat skeptical. I think when backlogs build up, they tend to simply grow. Do you have any thoughts on plea bargaining? Because that seems to have been what has happened in the States in terms of trying to deal with the vast volume of criminal cases that come before the courts there.
Yeah, thanks, Brendan, for that. Well, Brendan's one of our most distinguished graduates. I'd just like to mention that he was last Friday night week, I think he was made a bencher of the King's Inns, which is a rare honor. So congratulations to him. It's good to see one of our graduates getting such distinction and well-recognized distinction at that. Plea bargaining is an interesting one because it is a concept or an expression that covers an awful lot. Very often when we talk about plea bargaining, we think about, I suppose, what we see happening in America, where the defense and the prosecution will actually bargain quite overtly. Usually the prosecution will greatly overcharge. They will bring about 24 charges where one would do. Many of those charges will carry heavy mandatory minimum sentences. And they say to the defendant, look, if you're willing to plead guilty to 2 of them, then we will drop the others and we'll recommend a fairly lenient sentence. And usually the court may accept that. In this country, we don't have that kind of overt bargaining. But we do, of course, have significant reductions for a guilty plea. Now, in England and Wales, the Sentencing Guidelines Council has done a fair bit of work on this. It has produced 3 different guidelines over the past 20 years or so on discounts for guilty pleas. And all of those guidelines have been intended to promote early guilty pleas. And so they say, well, if you plead guilty at the first opportunity, you get 1/3 reduction. If you leave it the last minute, you get 1/10 reduction. Actually, our Court of Appeal here has said the same thing. It's just that it isn't formally in a guideline. So the point about it is there are people do get significant reductions for pleading guilty, but we have to be careful about it because we don't want to make, and this is one of the kind of the standard objections to it, we don't want to get to a point where innocent people actually plead guilty just because they want to be assured of a lenient sentence rather than run the risk of a conviction. But, you know, one of the questions is, should we maybe increase the level of discount that's given for a guilty plea in circumstances where we are trying to, if you like, clear a backlog of cases and keep down the prison conditions? I think we could think about that. It can be politically divisive. I mean, when King Clark became Home Secretary in England back in the 2011, he was recommending that guilty pleas should get up to 1/2 reduction. Immediately, people, as you can say, well, does that mean that if somebody was charged with rape, that, let's say, carried a 7-year sentence, they would simply get 3.5 years of the sentence? And then, of course, they would get out at the halfway mark anyway, so they would only be serving about 1.5 years in prison. So there tends to be a bit of political resistance to giving too much credit for guilty pleas. But it's certainly something we could look at. It's also something that we could you mentioned COVID there. And English courts have been saying that, yes, where COVID is a problem and it creates more difficult prison conditions, that's a factor that can be taken into account. Likewise, I think they would say, and we could possibly say, where you have prison overcrowding, that is a factor that can be taken into account as well in setting prison sentences, because you know, the experience of imprisonment can differ greatly depending on whether you're in pleasant conditions, insofar as prison is ever pleasant, or in thoroughly unpleasant conditions. That's another basis on which sentences might be reduced somewhat. But when it comes to, just to try to get back to your question, when it comes to giving credit for a guilty plea, as I say, we should be generous, definitely, but not to the point where we kind of deprive people of a true choice as to whether they should plead guilty or plead not guilty. Therefore, we have to strike a kind of a difficult balance between rewarding guilty pleas, but not, if you like, rewarding them to a point which might cause miscarriages of justice.
I'm going to end it on a lovely superficial note. That's good. Firstly, thanks very much, Tom. As you know, this isn't my area of law at all. And I engage, I suppose, with sentencing, like many in the public, through the newspapers, through social media, and seeing stories around it. And I'm really curious about your thoughts around particularly the use of, I suppose, character references, the local character police, the local GAA turning up and saying that they're from a great family, and how that impacts on sentences, and I suppose the influence that has in general.
Well, of course, it's very common to have character references, but quite frankly, I'm not sure of what impact they actually have. You know, do they actually affect judges? There are others here who might be able to say that or not, but I mean, I think a judge is well able to assess a person's character from the evidence that's given, rather than have a whole rake of character references. So I'm not sure that they have that much impact. It tends to be mainly in the area of sex offences that this becomes an issue. And that gives rise to a deeper issue, which hasn't very much to do with character references. It's very often the question of, should a person get credit for previous good character when they are being sentenced for any offence? And there tends to be, I suppose, some acceptance that they should for anything other than sex offences, or particularly where a person has been sexually abusing children, one or more children, over a long period of time. People say, well, that person is not of good character anyway, even if they have no previous convictions. It's simply because they haven't been caught until now. And therefore, courts have said, when we accept that, what we're asking is, has the person otherwise been of good character? And of course, you do come across the entire complexity of life. You know, I've often seen cases where a person has been committed atrocious abuse of children, but yet, of course, they were also doing good things. And it's the question of whether, in fact, the good things should be completely ignored and the bad essentially being the only thing that matters. So, I mean, I think that, yes, previous good character should have an impact on sentence. The extent to which it should have an impact on sentence will vary with the circumstances. it can be cancelled out, obviously, by a long period of persistent offending. But quite frankly, I don't think there'd be anything to be lost if we got rid of references completely. You know, I mean, people sometimes feel good about having them into court, and maybe they do have some slight impact at times, but I don't think they have anything like the impact that some media commentators would suggest.
Well, ladies and gentlemen, I think this evening we've all seen why Tom's lectures were full at 6 p.m. on a Friday. I think we've all seen why, as Justice Charlton said, the judges of the country look forward to Tom presenting. We did a real tour de force this evening. We went from the wisdom of Aristotle, we went through the sage advice of Lord Mansfield, that great Scotsman who fled to another country to continue his career. We went through the wisdom of American judges and sentencing guidelines, and we got some incredibly important reflections on the future of sentencing in Ireland today. And we heard in those reflections the wisdom of a whole career boiled down into tonight's lecture, the way that Tom has reflected, the way that he's thought incredibly hard about his subject over decades. And I think his colleagues, his students, practitioners, we all appreciate that wisdom. We have so much to learn this evening from that lecture. Tom, thank you so very much this evening. Thank you for all you've done in your career at Galway. This was your last lecture before you retire, and really what a nunc dimittis it was. So thank you very much on behalf of everyone this evening for a fantastic and very distinguished annual lecture.
Thank you very much.